pleasure, Lordship. My lord, with the concept of the other side, the back to mention item number 17, Lordship.
17.
Lordship, there is some inconvenience of Mr. Ejketa's Lordship. Lordship, may kindly take up this matter after deliberation, Lord.
As paid for on behalf of
Mr. Ejketa's
appellant,
Lordship.
on behalf of the appellant, re-notify on the date after. Sometimes in April, right? Or maybe May. Yes.
11 May.
Lordship. Deeply obliged, Lordship.
From item number 18 to 31, 18 to 28.
Milord, praying for indulgence, Milord.
Yes.
In item 25, we have filed an affidavit, Milord. Can it be called for? Milord?
Item number 25.
Yes, ma'am.
We'll hear you tomorrow. Is this for 50% back wages?
Yes, yes, ma'am.
So tomorrow, today,
My lord,
I'm calling for it and then I may not reach.
my lord.
So let it,
Yeah.
tomorrow, day after tomorrow.
Yeah.
Day after
Well,
tomorrow with what you're filing.
From 26 to 31, I'll be out of station. Milord.
So keep it after April.
My lord, as your lordship pleases, Milord.
And it's spread for on behalf of the,
I'm the respondent 4 and 5, Milord.
on behalf of respondent number 4 and 5. Counsel for the appellant is present.
No, my lord. Oh, he's here.
So we are keeping it immediately after the,
My lord,
maybe on 21st of April.
deeply obliged. Milord, shall I-
You have been reinstated.
But they did not allow us to join, Milord.
That we said somebody was arguing. We had said that let them join that.
But they did not allow. I went.
Have you filed that?
Yes, that is that.
All right, we'll see on 21st. Then we don't even reduce that amount. We might think of increasing that amount.
Well, that is that we
If
have
not
brought.
allowed you to join, that will take necessary action.
That we have brought on record by filing this affidavit.
All right, who was the payment? Oh, all right,
My lord.
27.
21st.
21st, yes.
My lord, in respect of item number 23, appellant has filed an affidavit on Friday. That is not on record, my lord. Let it come day after tomorrow. My lord.
Day after tomorrow,
Second,
2023.
May pleasure, Lordship. Lordship, with due consent from the appellant side, Lordship, I beg to mention item number 27.
Yes.
Lordship, kindly the matter will be adjourned only for the day, Lordship.
Only for the day, it doesn't come tomorrow. Mr. Chaudhary, you are referring this matter?
I am on behalf of Mr. Chaudhary.
You are on behalf of Mr.
R. Majumdar, my name is also there.
Your name also.
R.
Like, we
Majumdar.
can see Mr. Chaudhary also sitting in first row. After 1 week,
Lordship.
as prayed for on behalf of the appellant. Re-notify next week.
Lordship, in this
31st March.
departmental Lordship.
Okay.
I would like to file an affidavit bringing in
Can you file it within a week? If not, we'll give you further time.
Yes, your Lordship, for the time will be granted.
As jointly prayed for, let this matter come up for consideration on 22nd of April.
And so obliged, Lordship. Obliged, Lordship.
Any other request? Daily list, item number 18 to 20, matter fixed at 2.
We were at which point when we adjourned last? You'll have to remind, both of you will have to remind us.
But before that, my lord, I think in the item, the other item, PL 67, I think state of Nagaland was supposed to file a counter. My lord.
That's a separate thing. We'll find it. That has got nothing to do with this. These two are very limited. It was D-tagged, madam. This matter was D-tagged.
If they, without filing the affidavit, they want to take a chance, I have no problem.
We are
I'll
not
argue.
arguing that. That is D-tagged.
So that matter is also in the list together.
That
That's
may
why
be in the list. It was mentioned, it won't be taken up.
Clearly says that
Initially, it
issues are the
was tagged.
same, issues are the same.
I had.
And certainly issues are same.
These two matters are the
If they
same.
want to take
This
a
is
chance by not filing an affidavit, we don't mind.
No, you don't make such great comments. We also know. So as far as this is
I think
concerned.
my
as far
learned
as-
friend
as
has to
this
mind
is-
his
as far
language,
as
my lord.
You mind yours. You
No,
unnecessarily keep interfering.
Please don't do this.
You don't interfere unnecessarily. When I'm speaking, why are you getting irritated?
I
It's my
will-
petition.
Mr.
Did I say I will argue it?
Mr. Balgopal address us. Mr.
Oh, my
Chaudhary,
lord,
you
what
are-
is this, my lord? I am the petitioner, I stood up.
look at this. Now,
I followed, my lord.
can we tame two senior advocates.
No, it's not a question of taming, my lord.
So therefore.
There is
you
a
have-
way of making submission, my lord. This is not the way.
Mr.
At
Palko-
least we are not used to this type of submission.
Mr. Palko-
We know-
Maybe in his place, original place, it may be
I
not
am
in
very,
Gauhati.
very well aware of your language in the court. Forget it. My
Not
lord,
forget
as
it.
far as
Don't
we
serve
are-
this
as far as we are concerned, my lord,
See, you
No,
are,
it's too much, my
there were
lord.
two
Mr.
petitions.
Chaudhary,
And I have noticed him, my lord, invariably he does all these things.
Yeah.
Mr.
I don't
Chaudhary
think
and
I
Mr.
have a reputation for that.
Yes,
Please.
you have the
Who has
reputation.
the reputation,
You have
everybody
to
knows.
yourself.
Yeah.
I'm sorry, my lord, I
So
don't
what are
mean
you sorry
that.
about? You keep on shouting when I come.
That means I can't even make argument.
Lordship will be listed with that. Lordship will be listed with that, but it's not tagged. So as far as the third matter is concerned, my only prayer is
In that case, Mr. Chaudhary,
Yes.
we have passed an order on 20th of February.
No,
2027.
no, yes, earlier there was an order, but subsequently the other day, my lord, Lordship wanted to hear both the matters together. That is how they, if it is detailed, why these two matters are listed together? On last occasion, this aspect did crop up. Then eventually Lordship decided that no, we'll hear it
Is
together.
MS Crow had mentioned that day that this matter should not be tagged along with this.
that's
So we said, all right, but the issues will be cognate.
yes.
So we will be hearing it together.
Yes,
But it's like this, madam. Issues in the first two are the same. ILP. They're very clear.
Okay.
The other is completely separate.
Okay.
So as far as the first two are concerned, where pleadings are complete, we'll complete them. As far as the other one is concerned, we'll file a counter affidavit. It can be.
Can we do it? Can we do it together, Mr. Malgopal?
My lord, I think it's better we complete the first two. If it's okay with your lordship. Otherwise, I will leave it.
Yeah, because we have to hear both of you. But then the judgment in this will be postponed.
no, in fact, my lord, I'll be
We can
relying
hear the
heavily
first
on
two.
2-3 documents in the other place.
Common documents are
I
there.
can start, my lord. That's why I said I have no difficulty.
Mr. Palgopal, look at, just here, I say these two articles.
Sorry.
He says that he'll be referring to many of the documents
Yeah.
in PIL 67. He says, now, can it be done? If it is ready, it can be done.
My lord, I will just make one humble submission.
Yes.
What is this case? 3 points. Your lordship.
No, before you will have a right to argue.
No, I will just say why it has no connection at all. He says the arrangement of Dimapur, it was given to Nagaland by form of some lease deed also. That is one submission of that. Second point is Dimapur was never part of Nagaland. That is the second.
That is the most important point, but then we asked for that document of 1962.
Yes, but that you don't find any answer to this in the third petition. I will leave it to your lordship. If your lordship feels all have to be heard together.
So let you, are you,
We'll
any
do these two
problem, Mr.
petitions.
Chaudhary, we can adjourn it for his affidavit in that case. If there is no problem, you can.
You can argue
I
the first
thought,
two minutes.
I thought maybe
It has come up many
because they
times.
took time, maybe they will be filing their
No,
affidavit.
that
That's
was-
why I started
that
with
was-
that argument. I have no, otherwise I came prepared, my lord.
He had got it tagged because of this reason. Your lordship had gone into it. So we will hear these two and this will be tagged.
Your lordship,
So let us two matters be heard first. And thereafter, any day can be fixed for the third. I did not say that I will argue the third without filing affidavit, which you were saying. That was my concern. I will argue it after filing it. I leave it to my lordship.
no, your lordship, the Dimapur issue is here also, both the matters, Dimapur issue, whether Dimapur.
Then I'll start.
So any judgment in these two, any argument in these two, it would be true for that also. He's here.
And end of the day, my lord, these are all questions of law. In any case, it can be proceeded. I'll proceed, my lord. Because these people are coming every day, doesn't look nice. Yes, yes,
Mr. Chaudhary, otherwise I would have adjourned.
yes.
But for the reason that Mr. Palgopal has come all the way with his team from Delhi, so we should not go without
Yes,
hearing you.
yes, certainly.
Hearing you, we should not go back. Yes.
Now, my lord, first lordship will kindly take.
You want to start a treat for the frayed tempers to cool off? We can proceed with the other
No,
matters. And
Very
at
fine.
3 o'clock, we will hear all the-
My lord, I am used with such adversaries, my lord. I don't care on this. Please take this PIL 22 of 25.
Yes. Yes. Yes, other
My lord,
sheets of paper. sheets.
My lord, the fact that I'll be
This will take some time, no?
half an hour.
So I don't think other matters would be taken up. So if you have other matters. No, we are not adjourning. We are not adjourning. We are not adjourning any matter, and Mr. Counsel, no interim relief in any case in such matters. We would hear it. We are not adjourning. Did you not hear? We are trying to hear the matter today. So I'm asking for others, those who are not in 18 to 22. If you have other matters in other courtrooms, you can go. Yes.
My lord, I'll be making arguments referring to those very aspects, my lord,
Just give,
that Nagaland.
just give a brief background
Yes.
first.
No, Lord, we are agreed by an order whereby for the purpose of ILP, the peoples have been divided into three classes.
No, first let us see the order first.
Yes.
Show us the order.
Important order is at page
would be
59.
That would be part of your argument.
Yes,
But let us have the facts first.
page 59
Page 59 of
Yes.
the brief or the
of
compilation.
PL 22 of 25.
Page.
Page 59. In supersession of this department's earlier notification
One
of
second,
event number dated so and
One
so
second.
and so and so, I'm sorry, Milord, page 59.
Yes. Yes. Yes, sir.
In supersession of this department's earlier notification of event number dated 9/12/2019 and 26/23, and in exercise of the power conferred under section 2 of the Bengal Eastern Frontier Regulation 1873, and in the interest of public, Governor of Nagaland is pleased to extend the inner line to cover the district of Sumukedima, Nuland, and Dimapur. Inner line permit will be implemented in the district of Sumukedima, Nuland with immediate effect. ILP in Dimapur district shall be implemented under the following categories. Category 1, prior to December 1, 1963. What document to be checked and verified? Entry in the electoral roll of 5th of December 1963, or land property patta permit of 1st December 63, or house tax of 1st December 1963, or any other government document record citing that they have been settled in Dimapur prior to 1st of December 63. Now, what should be, required, my lord? Smart card with option to avail PRC and domicile.
Yes.
This class of people is exempted from IL.
Yes.
Then second category is from 2nd of December 63.
These are exemptions, exempted category.
Exempt. Milord, let me read it, Milord. From 2nd of December 63 to 21st of November 79. Then entry in the general electoral roll between 63 and 79. Town committee council electoral roll between 2nd December 63 to 21st of November 79. Or landed property patta between so-and-so to so-and-so, or house tax. And not only the period matters, otherwise the requirements are same. Then what would be the issued? Permanent residence certificate with option to avail domicile certificate. They are also exempted from ILP. Then there is a third category. 22nd of November 1979 and beyond. all required document for ILP as notified by the government from time to time. ILP is mandatory. For anyone who is there from 22nd, wants to enter Milord, are there beyond 22nd of November, then for them ILP is mandatory. Now let me read the other three clauses, Milord. Deputy Commissioner will set up an administrative cell for identification and enumeration of individuals belonging to category 1 and 2. This exercise may be completed at an early date. During the intervening period, people under category 3 shall apply for ILP.
Yes.
Deputy Commissioner Dimapur shall issue 30 days permit at nominal rate to daily wage laborers coming from neighboring states. Any person from other states passing through district of Dimapur, Sumukadima and Nuiland as a transit passenger, traveler and having a valid ticket will not be required to obtain inner line permit. That means a person who passes to Dimapur and other two districts, in their case, there is no question of ILP. And for the daily laborers and all, they will be issued 30 days.
Is it very unreasonable?
Milord?
Is it very unreasonable?
Yes, in the context of the facts which will be projecting. Milord, for a
Now,
moment,
especially clause 5
yes,
of this notification.
yes,
If you're somehow the other, while en route to some other destination,
Not
you cross Dimapur, you don't require. If you're in transit for a day or two and you have valid return ticket,
Milord,
then it is not
Milord,
required.
it is unreasonable from the point of view of the petitioners.
Now let
I'm
us,
not saying, Milord, it is unreasonable
Now you-
for me.
you,
If I travel to Nagaland, certainly they have every right. All of the fact that we are referring to the earlier history is to show our affinity to the place. In such a situation, whether it is reasonable or unreasonable, that is the question. Now, just to appreciate our case, Milord, I'll refer to my averments in paragraphs 23, 24, and 25. At page 15. That in the preamble of the regulation of 1873, it is provided that regulation is applicable inter alia in Naga Hills, and section 1 provides the local extent which says these regulations shall extend to the districts named in the preamble and shall come into force on 1st of November of 1873. Section 2 empowers the state to prescribe inner line to prohibit all, including citizens of India or any class passing through the district without pass. Section 3 imposes punishment. Section 4 wastes power of the state to prescribe the form and restriction. Under Section 5, items mentioned in this section would be confiscated if found in the possession of the offender. Under Section 7, earlier, the British subjects were not prohibited from acquiring interest in any land or product or land, etc., but now that has been deleted. In the impugn notification dated 29/24, rules have been made. Rules are discriminatory, violative of Article 14, 15, 19, 1D of the Constitution. Persons, parents named enrolled on 1st of December 1963, land patta, house tax, and other documents obtained paid before December 1, 1963 are exempted, but they would be required to obtain smart card. And person whose names are enrolled in the electoral roll of 78 and or town committee council electoral roll between 2nd December 63 to 21st of November 79, or having permits houses prior to December 21 November,
that's right.
December are exempt. However, they would be required to obtain permanent certificates and domicile certificate. That
No,
every day,
Mr. Chaudhary,
yes.
therefore, this, you admit
Uh,
that exemptions are in place,
Hmm.
but then you'll have to obtain permanent certificate or domicile certificate. Now, from 78 till 2026, you must be having if you're a permanent resident.
No, Milord,
Now,
that,
if you're only talking
no,
about
I'll come to this.
rationale of the government, or you're taking Dimapur to be not part of Nagaland.
No, for a moment, it is not our case that Dimapur is not a part of Nagaland. No. But we'll be referring to those documents to show that that when you insist upon those people to have an ILP, it's an unreasonable. But I belong to this place. I'm living there. Then where is the question of I obtaining an ILP?
It's a very uphill task, Mr.
No, my lord, I'll satisfy your lordship.
We'll see the history if you so like.
Yes.
Then we will see the document by which it became a state,
Hmm.
and the authorization documents,
Yes.
adaptation documents.
We are only dealing with those classes of people, my lord, who are there. Now they are made to have this document.
Okay, we stopped you midway. You can read paragraph 24 on this.
Yes, yes. That everyday parents come to Dimapur from Assam to drop their children at schools and colleges. Traders come to Dimapur from Assam to purchase goods from wholesalers. Patients come to Dimapur from Assam for medical treatment. Traders from all over India come to Dimapur for business in Dimapur. And entire Nagaland, and every day hundreds of laborers come by train to Dimapur from Assam to work. The Kacharis and Garos of Assam, who are married to local Kacharis and Garos of Dimapur, come to meet their relatives in Dimapur. It is very absurd to notice that land of Dimapur has been used by the Nagaland government for convenience of the hill tribes, but now men including Kacharis and Garos from the plain area cannot freely come to Dimapur. Economic hardship and inconvenience would be inflicted on the people even the impute notification is not state. That the petitioner states that the contents of the lease is signed with the government of Assam. Anyway, I am not pressing this, that this is not an issue. Now the question is, my lord, the people who are from Dimapur originally, supposing they are now partially settled in Assam, now to go back, they will require an ILP. Now, my lord, please take the other petition. I'll refer to. No, I don't know why I'm saying so.
Chaudhary, you have to frame your question. If you frame a question, the answer would be no either way.
No.
Now frame a question in such a way
Yes.
that it clinches the issue.
Yes.
Question is this. Now somebody who is not a permanent resident of Dimapur, while traveling to Dimapur beyond the transit period, will require an ILP.
Yes.
Correct.
Correct.
So if he is en route to some other destination via Dimapur, he doesn't require. And all those people who are, if they have the permanent resident certificate or smart card, they don't require. So it's all a question of your residing or not residing there permanently. So that's all.
No.
So if it is true for other areas of
Let us first see the background facts. Then I will articulate my points. Kindly permit me to do that. Please have the other petition for a moment. I'll refer to 4 pages. No, my lord. Those documents are very important for my formulations. Please have the other document, my lord.
Yes. Which
Please have page 134.
in this document only.
Other petition, other appeal.
PL 67.
Yes. I'm just giving the background facts, Miller. Then I will come articulate my point.
Yeah.
This is a
Page
notification
164.
134. The governor of Nagaland is pleased to decide that in order to qualify as an indigenous inhabitant of the state of Nagaland,
Which page?
page 134 of PIL number 67 of 25.
I am yet to file my counter in this. And yes, crossover from this to the third
Now,
petition.
that is what, Mr. Balgopal, that is the first submission that he made, that I'll be referring to these documents.
Then-
Let him complete his argument with respect to this, because otherwise also we'll ask you to file the affidavit with this.
When you file a petition, my lord, he makes certain challenges. He cannot take that petition with a pretext to some other area. So I'll come to that,
Mr.
Mr. Give my
Balgopal,
reply.
that objection we are not taking presently for the reason that he can always take time to file a supplementary affidavit in this petition.
Mhm.
But then that doesn't serve the purpose, no. Because they are willing to have it decided today, I mean, what to do? Somebody made a mention that please give us interim stay. So if we ask them to file, but Mr. Chaudhary, if you argue this case, you need to have documents in place in this case, no?
No, my lord, these are all technical, my lord. We can file an additional affidavit to bring on record those. But since both the matters are before your lordship, that's why I thought, my lord. And considering the issue involved, that's why let us not go to all this technical.
And these
We
documents.
have no
don't
problem. The
support
problem
pleadings.
is with you people, no?
They don't support the pleadings.
And my lord, my
Mr.
learned friend
Mr.
will get his
Bhatt,
time to reply.
There can be two solutions to this.
Well,
Now, mediation 2 is in place. So I think we can be a mediator between you two.
no, but that
You
is,
can-
no,
Mediator between you two, not over the issues,
Yeah.
or the way it has to be handled. Now, either you file a response to this or allow him to argue and make cross references, or we ask him to file an additional affidavit in this, the other PIL which you are addressing.
I would put it in just 2 minutes, with the lordship permission. He has left all the grounds which are there in the PA. He left legally. He has left the point that Dimapur is now a part of Nagaland. And the only point he said was,
That day he said that after seeing the notification, he said
Yeah.
that he will recalibrate his
once
action.
all these 3 points are over, the petition has to be dismissed. Nothing else is left in that. You see, petition wise, whatever he may bring or he may not bring, these were the 3 challenges. All the 3 have gone. And what he's talking about, if your lordship were to see in this very petition at page 101, floating population, no ILP, students, everything were given categorically. So he has left all that. So let that petition be decided on the pleadings of that petition. That is how matters are heard. Not that he says that on the 3rd petition I'll go, 4th petition I'll go. That is not his case. It's not his case. They are on indigenous inhabitants. The next one.
That's all right. Either allow us to hear both of you separately. He will be making cross references because, or you file your counter additional affidavit.
Let him argue, madam. But my objection will be restricted
Your
to
objection, we have seen.
whatever is in the petition. That I am very clear about it.
But
Because we are hearing that particular petition. We let him concede he has no merit in that first petition. How can he have merit, my lord? He has left out Dimapur.
अच्छा issue देखते हैं. We'll see. We'll ask him to.
Nothing is left. Now he's going to 3rd, 4th, 5th petition. Let him go.
Yes,
I have
Mr.
no-
Chaudhary, would you file additional affidavit here? File it by tomorrow.
No, tomorrow it can be done, my lord.
Anyway, these documents, you take it out from these
No,
documents.
no,
file
it's
it.
not that. No, tomorrow that Sikkim matter is fixed. So I'll have to work out my.
Same code. Same code.
No, no, tomorrow that Sikkim matter is a heavy matter. Tomorrow I intend to take some time.
Day after tomorrow, we continue. Sikkim and Nagaland, both we decide. That's
Well,
not,
then lots will have this matter on Monday next, my lord. Monday or Tuesday.
Mr. Balgopal.
Up to 6th April. 6th April. I came specifically because I thought in the morning we had a case in Nagaland.
Therefore, we are not doing it despite the fact that this court has resumed only at 15.
I'm grateful to. We had
One of us not being here.
a matter in Kohima, you know, we have appeared in BC, it was just over. After that, we came directly. To be very fair, my lord, when a person is filing a petition, I have filed my response. State of Assam has filed the response. No pleading is there. So he has to travel within that. Which is the law which says he can take ventilation from some other case? Where is it? And where I said that I'll file reply. So let him concede he has no case. He has conceded. He said Dimapur, I agree. Then he said, what is it he has not agreed to? He's not talking about the constitutional validity. Dismiss that petition.
My
first,
lord,
madam.
is it my,
Hear
is
it.
it my case in the first case that Dimapur should be taken out from the state of Nagaland?
That
Is it the
read-
challenge?
Read your petition. I will show you. His whole.
No, but that is not the
whole
case. You are
is-
challenging that notification whereby ILP has been made
No, no,
mandatory.
You see, it's pleadings, my lord. Dimapur, it was never there. It was never there. After making the allegation, he admits, he concedes.
Anyway,
Let him complete the first petition, man. Let him take anything from anywhere. Let us
can't
complete.
proceed with that.
No, let him refer to the proceeding. Let us
Okay,
understand.
very well, very well,
Not your objections.
very well.
Let us understand.
That's it.
Page 134.
Yes. Now, once your lordship read this, then lordship will realize where the shoe pinches. The governor of Nagaland is pleased to decide that in order to qualify as an indigenous inhabitant of the state of Nagaland for the purpose of employment, as envisaged in order dated 6/7/73, a person who should have settled permanently in Nagaland prior to 1/12/63. The following shall be the criteria for determining a person to have had a permanent settlement in the state prior to 1/12/63. His or her name or name of parents or legitimate guardian in the case of person was then a minor should have been entered in the electoral roll published on 5/12/63. Or the person, his or her parent or legitimate guardian should have been paying house tax prior to 1/12/63.
Yes.
Or the person, his or her parents or legitimate guardians should have acquired property and patta on it prior to 1/12/63. It has been further decided that only those certificates issued by the deputy commissioner or additional deputy commissioner shall be accepted with immediate effect from the certificate as annex shall be used. This supersedes department's notification.
Mr. Chaudhary, the difficulty is that we are not seeing any red herring here in the context of the manner and the why Nagaland state was created.
No.
Now it has been diluted, no?
No,
Either
not-
your parents' name.
All that I'm saying is, my lord, same government of Nagaland has recognized would be an indigenous inhabitant. That person who was before in the state from 1/12/63. Now, in respect of the same class of persons, my lord, now another set of requirement is sought to be imposed, my lord. If they becomes indigenous inhabitant of the state, where is the question of subjecting them to, my lord, ILP or other regime?
No, but those persons who fall in the category of indigenous inhabitant, they would not be required to have ILP.
No, my lord, now this is not.
Further,
Now,
see,
this
you
is
have
sought to
look
be
at
diluted.
Mr. Chaudhary, you have to look at, no, I'm not trying to obstruct your argument.
Yes.
No, these are double filters.
Yes.
The filter gets activated only if you're not an indigenous inhabitant. See,
No.
if you
Question is,
if you compare the requirement for indigenous inhabitant and if you compare the requirements for ILP, I think it's only a filter.
where is
They
the
have,
question
they
of,
don't have.
where is the question of an inhabitant, an indigenous inhabitant being subjected to an ILP regime?
It's not being subjected to, you have to see it from a different ground.
Anyway,
Indigenous Just a minute.
there are two more pages.
One more. One second. If you are indigenous inhabitant, I think you fall in that bigger penumbra of exemption from
I'm
ILP.
coming to that, madam. Please come to page 135. This is regarding owning landed property, my lord. So this was an amendment of the Assam Land and Revenue Regulation, which Nagaland adopted it as Nagaland Land and Revenue Regulation 78. Now please come to page 136, my lord. Subsection 2 of section 2. Notwithstanding anything to the contrary in any law, usage, contract, or agreement, no person other than indigenous inhabitant of Nagaland shall acquire or possess by transfer, exchange, lease, agreement of settlement any land in any area
Correct.
constituted into bells or blocks in contravention of the provisions of the act. Then Milord will kindly come to page number 137.
You question this, question the correctness of this.
Yes.
You possibly can't, no?
No.
Because you possibly can't question this,
No, I'm not questioning.
right?
But then Milord, they say when it comes to acquiring land and etc., other than indigenous people cannot. Who are the indigenous people? Who were in the state of Nagaland prior to 1/12/63.
Correct.
On one hand, you are recognizing as the indigenous people, inhabitant of this state. No, no, Milord. It boils
Lens is
down.
different. Sir, your lens is different.
Acha.
You ask.
No, that's a different aspect. Then, no, please come to Milord, page number 137.
Yes,
Please come to 137, Milord. Page 137. Now kindly see, Milord, certificate of non-Naga indigenous inhabitant. A person from Bihar, Milord, he has been given certificate. Why? Because he was there prior to 1/12/63.
it is a proper and effective working of that notification.
Absolutely.
He may be
Now-
from Bihar, he may be from.
Anywhere, other than Nagaland.
Other than Nagaland.
Now the question is, Milord, now who are before the lordships? These are the persons who claim they are the sons of the soil. They are sons of the soil. They include, Milord, the petitioner's father was an MLA.
No, but if his father was an MLA, he also comes in that exempted category.
No, Milord,
Why?
that is the difficulty. That
Why?
is the difficulty. The problem.
What
No,
is the difficulty?
now, end of the day, now therefore my duty would be, now Lordship has posed the question, what is your right, argument? Now having placed these factual aspects, Milord, now I'll place my arguments. Now all that I'll say, Milord, these are all discriminating.
Yeah, no, you have jumped to the last
No.
point of your
No,
argument.
Milord, I have referred to these documents.
Discriminatory only, you can claim it discriminatory only when the state does not have power. It does it for some oblique purpose. The reasons are quick. As if discriminatory, what discriminatory?
When in a regime, when these documents were issued, Milord, they recognized as original inhabitant of the state. Now,
Tell me one thing.
over a period of time,
Tell me one thing. Indigenous inhabitant can only buy or sell land. No difficulty.
no, Milord, if a person can own and possess property in a place, how can there be a restriction on his movement?
No. बड़ा मुश्किल है 90s.
No, Milord, it's
Give this.
therefore the question would be, a person who owns a land, who otherwise have a right to settle in Dimapur, now if he is subjected
He
to,
is not put to any fetter with respect to free movement if he owns the land.
no, he has
The
to,
question is that if he surreptitiously buys land against the rules,
no,
sometimes later than 1963, and does not have any other supporting document to prove that he is an indigenous person residing there, he has a permanent residence certificate, obviously he would require.
that is not the case here, Milord. Now,
Yeah.
the petitioner,
Mr.
he
Chaudhary,
whose
can you-
grandfather was a member of legislative assembly.
Can you argue on the basis of isolated instances?
No, I'm not, no, I have just placed the facts.
We have some difficulty. You are finding it difficult. I mean, we understand that because questioning in the midst of your argument can disorient you. We understand that. But we are not able to accept that argument in the first place for you to be allowed to continue. The difficulty is this. If you don't question this PIL, you have one way out. Either you argue this PIL after the certificate is filed and don't press that application because all your document is here. Don't press that. That is absolutely without any merit unless we decide this. Either yes or no. Perhaps that way, I think Mr. Palgopal had a point which we now
In
understand.
that case, my lord, Lordship will give me some time, I'll file an additional affidavit, bring these documents there. Or Lordship, hear this petition, keep it pending.
Don't press this at all. Press your PIL. We give you time. You will file
No, my lord, let this also be there, my lord.
it will come only after we decide that case. Otherwise, you have no case, Mr.
No
Chaudhary.
problem.
And he can't
You
change,
don't have a case.
he can't change his pleadings, madam. Unknown.
No, there is no
Unknown
question of
civil-
changing the pleadings. I can always supplement my pleading. There's no question of changing the pleading. My lord, when we bring all those,
Supplementary is not required. If we decide this PIL, I think your decision in that.
yes,
case-
yes, if your lordship, this, that I agree, my lord. If PL 67 is decided, it will automatically take care of this grievance raised
We
here.
give a long rope to that. Is there any stay operating?
No, no.
So, Mr. Balgopal will have. no-
All that I'm saying is, my lord,
You
let it
just
be,
argue
let
this,
it be tagged with this, but let it come
Tag
together.
नहीं करेंगे, पहले उसको डिसाइड करेंगे,
हाँ.
इसको डिसाइड करेंगे.
हम्म.
ये आप बस करिए इनके बिना. He is prepared. He may not file affidavit. You have to make out a case. आप 67 बस करिए.
Because you're asking me,
Yeah.
oh yes,
asking you. You-
in
you
this
argue
case,
this.
in the second case.
And Mr. Balgopal, is it emergent for you to file your affidavit? Don't go by technicalities.
We will file it. We are just processing it, we'll file it. But kindly bear in mind, we'll do all what your lordship says. That whenever,
Mr. Balgopal, you have followed what we are saying. He can't proceed in that matter because the grand rules are here. So see, we are not asking him to abandon that petition. We will not tag it. We will hear it later only after this is decided.
that is, we will file our counter, that's no issue. But as far as the present petition is concerned, he has to stick to his pleadings
That's
in
all.
that
We have-
petition. That's it, that's all I have.
But so he says that even if it has to be dismissed, let it be dismissed after this PIL 67.
After,
PIL 67 is decided.
oh, good.
That we can't insist that you concede now. That right here.
We can do one thing, my lord. We filed it in this situation, first, second. In this, Assam has also responded, pleading their complaint. So let us, the lordship may not pass any order that your lordship's discretion. Let us finish the argument on the first and second
He
petition.
can't proceed now. Difficulty, Mr. Balgopal, you have caught him by the jugular. He can't proceed in that matter unless we decide this. The difficulty here is that all his grounds will be drawn from this document. So therefore, Mr. Chaudhary is slightly on the back foot. अभी इसको बहस करके क्या करेंगे? This which he started, what will he do? He'll come back to this. We don't tag it along with this. Anyway, you are enforcing ILP, aren't you, Mr. Balgopal?
My lord?
You are enforcing ILP notification.
Yes, we are.
So where is your
And
difficulty?
last time his argument was different. He
Last
said-
time his argument was different, but the moment he saw that 1962 document, he said that I will recalibrate my arguments. Let him do that. We will not choke him to death. We are not passing any interim order. we cannot restrict an argument. Let him be satisfied. Prima facie, we are of the view that Nagaland's, after the creation of Nagaland state, and this not being unreasonable, the restrictions being reasonable, and the requirement has been diluted with many documents and exemptions. See, three class of citizen, this argument may appear to be convincing for some time, but it is only for expanding the base for you people that three classes have been set. One, all right, if one is not suiting you, come to two. If two doesn't suit you, come to three. So therefore, this is for your benefit. They are not restricting it. They are not making pigeonholes differently. They are only providing you opportunity. And therefore, Article 19 is not hit. That is what Mr. Balgopal wanted to tell you. This is what we are trying to communicate. The difficulty is that after the creation, what we remember of the last day's argument was that in view of 1962 transfer, creation of the state, with all the attending documents and the adapting laws, they have the powers. Statehood ka matlab kya hai? We must recognize federalism. You know that it has been considered to be a basic structure of the constitution. We can't do away with it. Now, had it been very restrictive, we would have said, yes, you possibly can't do that. Now, this ILP you're bringing without realizing that apart from indigenous population, the others also require free movement. Therefore,
Lord, but in the PIL 22 of 25, state of Assam has taken a very peculiar stand.
state of Assam is a party here. It is
Yes.
basically between you. See, a state of
State of Assam has taken a stand, my lord.
that
that is
their
Action,
matters-
no, two. Action is violative of Article 3 of the Constitution, and two, my lord, during the pendency of the,
appears for the state of Assam here. That is not an argument which can be entertained.
no, they
That-
also
that
say,
is-
my lord,
That is not correct. In
That
fact,
is-
they considered in their counter affidavit two things. We are not aware of any such lease. As far as Dimapur is concerned, it was returned back to the Naga people, Naga district, way back in 2013. I'm sorry, 1913. 1913. And this case has to rest only on one law, that is the East Bengal regulation of.
BEFR,
Yes, Bengal Eastern Frontier
Bengal
Regulation.
East Frontier Regulation.
Regulation. Yes,
This is the problem of adjourning the matter. That day when I was hearing, everything was on my tips, but today also I have been able to retrieve
Yes.
facts.
so the Bengal Frontier Regulation Act, his case is based on that with only 2 points.
So therefore, we have put this option to Mr. Chaudhary. Now, this, we are not finding it to be restrictive.
so anyway,
Much
madam,
as I can-
Lordship has proposed that Lordship would like to hear 67 first, keep it separately, and this will be listed after this is
Because
decided.
this, because we,
Anyway, Lord, once,
presently, we are not finding any merit in this.
once your Lordship decides 67, everything will be clear. Everything will fall in
Put it
place.
this way, my lord.
No, Mr. Palgopal, you don't put it in any other way. This is the most reasonable concession. It's all right. So let Mr. Chaudhary do that 67 with your counter affidavit if you require it to be filed. And then this becomes infructuous, so to say.
Let him be done with the two petitions. Matter is over. Then we'll see the third one. No, even I just want to point out, my lord, as
Let the,
kindly bear with me.
Mr. Palgopal, let the horse lead the cart. Let the horse lead the cart. This Mr. Chaudhary is a seasoned lawyer. He knows that this other petition is useless. It can't survive.
And we are giving ILP to everybody.
That we have seen. Only on seeing this, we are finding it to be
Only-
non-restrictive.
Not that he is not getting it. He himself is a kacheri. He is saying that I am not fighting for others. He is fighting for himself also.
And state of Assam's concession here would not do.
No, there is no concession, my lord. State of Assam as a my lord, adversarial party has taken a stand that during the pendency of,
the state of.
yes, during the pendency of the original suit before the Supreme Court,
Let us see what is your.
Yes, yes.
Petition.
kindly see
What you were reading out. Let's see what's your prayer.
22, my lord. Yes. Our prayer is for interfering with the impute notification. We have never prayed for declaring Dimapur to be not a part of
No, no,
Nagaland.
but notification to declare a notification to be bad in the eyes of law, we need to see that the government did not have the power to do so. Or if it had power, it was utilized, it was used in a wrong way. Number three, that it is restrictive, unreasonable.
It is a fact, when I,
He has given up.
Take, you consult. Do you require? You should have filed your affidavit in this. You would have started
I
straight away.
just wanted to mention one thing. That definitely.
How, at what stage is your preparation for filing the counter affidavit?
We will
In
do
67?
2-3 weeks.
2-3 weeks. Why?
I won't be available also for questions.
That is different, but file your counter affidavit.
Give 3 weeks, I will do it.
Huh?
Or 3 weeks would be reasonable.
You file that counter affidavit latest by 20th of April, we hear on 22nd, 23rd April. This we are not, either we dismiss it or we
Not
adjourn.
22nd and 23rd, that 20th also, we have Nagaland Assam border dispute. On those days.
Tell me, give us a date.
We will file the affidavit. We will file the affidavit, keep some other date for-
You file the affidavit by which date?
by 20th or 21st of April.
21st of April, you file the
We'll
affidavit.
file it.
And you choose your date, we will ask.
Will, that'll be all.
Just tell us now. Huh? What urgency? That is what the other, if you don't understand which side the wind is blowing, you can make such arguments. It's your wisdom. Now, when we are not finding any good merit in your case, and you say that let it be decided and you are not waiting for 67 to be argued, what kind of an argument is this? You press your petition, forget about Mr. Chaudhary, you press a petition, we decided today.
It's not fixing a
That's why
date.
we are fixing a date. We are asking for a date for filing counter affidavit. See, don't show that kind of urgency when you are on a weak footing. ये तो इसमें बहस ही नहीं हो पा रही है. You're always making cross references to that PIL. What are you insisting for? How can you argue that this is restrictive? Unless you strike at the very power of the state of Nagaland to introduce this. How do we say it is restrictive when it is so wide with so many options? We will not find it to be restrictive. आप सुनिए जरा सा, just hear out. Don't see, merely by standing and saying something that please ensure, and we don't think. We are ensuring it, therefore we are asking him. Or if you want to separate your case and you don't want Mr. Chaudhary to lead you in this matter, you argue your case. He is ready. Mr. Palgopal is ready. आप अपनी बहस कर लीजिए, छोड़ दीजिए, उनका बाद में सुनेंगे, आपकी पहले सुनिए. Let us hear you first if you are in such great hurry. आइए आप इनकी भी केस खराब करेंगे, Mr. Counsel. You will spoil the case of Mr. Chaudhary also. भाई साहब इसमें point ही नहीं है आपके पास. You don't have a point.
Which petition is?
67.
Mr. Chaudhary, your case we will hear it separately after 67. Let us file an additional affidavit or do whatever you contest 67. Yes, आपका कौन सा है बताइए.
He delegated 67, Your Lordship. Mr. Chaudhary delegated 67. He has come later on, Your Lordship. Yes, we are there, we bypassing everyone.
Can you stop him? We told him.
No,
We
the
told
Your
him.
Lordship, he is leading the matter.
No, Milord, I am very happy with Mr. Chaudhary. I have already stated.
Then why you are?
I am very happy with Mr. Chaudhary. No, I am not saying that I am bypassing him.
Mr. What is your name?
Yes, and Pandey, Milord.
Mr. Pandey, wait for the counter affidavit to be filed.
Very well, Milord.
67.
Very well.
And please.
That I am not objecting, Milord.
No, your objection. Your objection.
I am very happy with that, Milord. I am very happy with that.
Where do you come from?
Delhi, Milord.
Everyone comes, I also come from Delhi.
We will have it listed on the same day but not tagged, Mr. Chaudhary.
Yes,
We are only adjourning the matter for 67 to be taken first. File your counter affidavit, give us the date.
The first week of May, Milord.
That would be too far off. Do it sometimes in April only. Because there is an order of the Supreme Court.
29th April.
Yes, sir. 29th of April.
Milord, could it be little earlier, Milord?
He has to file counter
No,
affidavit.
Milord, what I propose to submit, Milord, once they file their affidavit, if we get 3-4 days time, we'll file our reply also. Actually, Milord, the first week that CA matters are fixed in Supreme Court. First week of May.
So we keep it in May then.
May after 10th, Milord.
Huh?
After 10th, after the first week. First week, the matters are fixed.
Second, it's okay.
15th May, Milord. Is it okay?
15th May, okay.
15th.
Next again.
Items number 9.
Milord, if it is not inconvenient to the other side, could it be on 12th of May, Milord?
No difficulty. item number 19 and 20 में लिखिए. After some arguments, Mr. Kamal Nayan Chaudhary and Mr. S.N. Pandey, learned advocates, submit that it would be more appropriate if these two cases are decided after PIL number 67 of 2025, placed at serial number 18 in today's cause list, is finally disposed of. In PIL number 67 of 2025, the state of Nagaland is yet to file the counter affidavit. Mr. Balgopal, learned Advocate General for the state of Nagaland, submits that the counter affidavit in PIL number 67 of 2025 shall positively be filed on or before 22nd of April. April. It is imperative that prior to filing of the affidavit in question, prior to filing the aforementioned affidavit, the counsel for the petitioners in PIL number 22 and PIL number 29, as also in PIL number 67, shall be served an advance copy so that they may reply to such affidavit in case so deemed necessary by 24th of April. Let PIL number 67 be listed on 12th of May at 2 p.m. Thereafter, PIL number 22
15th
and
May.
22 and 29 also would be listed and shall be taken up.
15th May, I'll submit. 1/5.
12th, you are finding it difficult.
No, I'll file my affidavit in time.
No,
Date of hearing.
date of hearing,
15th May, 1/5.
any difficulty with
12, 15 I have difficulty, my lord.
14th you can keep it. 14th May.
एक consensus date बताइए. Tell us.
Yes, 14. Okay, my lord, 14.
14th at 2 p.m.
Very.
नहीं उसी दिन लगा सर नीचे लगा
Deep level.
please ensure that counter affidavit is filed in that. Otherwise you would have finished it today. In fact, we have fixed it. It is only for this case that we have assembled.
We
You
will
pick the
also,
date, we ensure that the bench is here.
we will also examine the relevance of ILP in the third petition also, when we are filing our objection.
Whatever you do, but we will first decide 67.
We'll do that. Okay.
Daily list for orders item 1.
Lordship, in this matters, Lordship,
Yes?
the matters are pending in Supreme Court.
Lordship. The next date is fixed on 5th of May, Lordship.
After that, you know.
Let these two contempt cases. दोनों में order लगाना, लेकिन ऐसे नहीं. Let these two contempt cases be listed for consideration under the appropriate heading. The last week of May.
Much obliged.
22nd May. Item 3.
Yes.
May be your lordship. My lord, this is an application for condonation of delay, madam, in filing the IP.
Yes, what do you have to say?
My lord, we have filed our
So
objection.
that we have seen.
Lord, here the main.
But don't appeal to be processed, take their names. Like you.
25th May. For admission item 4.
Please, your lordship, I'm for the appellant, your lordship. Lordship, this case has become infectious. We're praying for withdrawal.
You are Mr.
I, Bhattacharya.
Mr.
I, Bhattacharya, Lord.
Mr. I. Bhattacharya, learned advocate for the appellant, seeks permission to withdraw this appeal as it has become infectious. In fact, we wanted this statement on the earlier day.
Yes, Your Lord.
You sent somebody without briefing. This person has become infectious.
Item number 5,
Actually, we have preferred, it appear against the judgment of the not single judge. Hereby notification 56 has been held to be ultra virus. I want to inform Lordship that all the high courts except our high court has
We have seen that.
upheld the validity of
We adjourned it to June.
Lordship Supreme Court as matter is pending before the Supreme Court.
So we are adjourning the matter. Is there a correction? I don't think.
It is not mentioned. actually.
Again, let this matter be listed in the first week of, on so and so date in June. There's about 7310,
Yes, my lord.
168. And
Yes, sir.
we had heard this matter, no?
No, Lordship adjourned the
How
case.
the facts are fresh in my mind. This is with respect to 2 financial years. It was
No.
extended.
No, Lord. Here, Lordship, a question of.
That's right. So it is only limitation for what? Limitation for assessing whether the
Yes.
for evaluating whether the assessee has hidden tax. I think it's the same issue.
Lordship, by notification 9 and
7310 and 168A. I think it's the same thing, no?
Lordship, probably this is a.
Impossible.
Here, no, no,
COVID
Lordship,
period
here
or
what.
any difficulty.
Yes,
I think it's the same issue.
9 has been already upheld by the single judge.
All right, yes, next.
Lordship.
We
item
were
6,
Testing whether we remember correctly or not. It's the same thing, 168A and section 7310.
168 is involved in this case.
All right. Some other case we may have heard that.
Not.
Yes,
Lordship, there is a caveat, his name has been shown, Lordship. Matter relates to the grant of non-functional special grant, Lordship.
non-functional grade pay.
Great, Lordship. Our contention is that he should get from the date of regular promotion and not from the date of MSCP.
Not a required. Again. Mr. Chakravarti, we are not saying anything. For the reason that we thought that the entire time would be consumed by the 2 advocates, Nagaland.
Lordship,
So we.
perhaps on that assumption, you might have left.
Otherwise, we'll issue notice. He is on caveat. Has he filed his wakalat?
His name has been shown.
His name showed. Anyway, they have to let this matter come up for consideration for inform him after a week.
first April. 1/4. Item 7 to 12,
Well, in this case, state has filed their affidavit today. So would like to file a reply.
In view of the counter affidavit on behalf of the state having been filed today. Mr. Kamal and Chaudhary, letter senior advocate for the petitioner, seek some time to go through the same and file the rejoinder in case so deemed necessary. Let this matter come up for consideration of May.
After 10th, after 10th.
15, 16.
Yes.
that's what you want.
Well, that interim order has to be extended.
What order? Interim order?
Yes, earlier Lordship has extended the interim order.
Interim order, Bethany, I have not.
Lordship has not given, but Lordship has extended it on 2 occasions.
Some other bench. having-
Bench has given.
This cannot be done. no?
On 2 occasions, Lordship has extended.
So status quo what?
Possession.
And is it creating difficulty for the making of roads or
No, no,
airport?
no.
Nothing of that.
They want to build a city or something, Aero City or something, that's the plan. Lord, how can
Mr.
we,
Gogoi,
Lord,
You're appearing.
there could be
Mr.
an.
Gogoi, you're appearing for the state. Additional Advocate General, how can you sit tight in the corner?
No, Mr. Bopuzar.
Board Puja is.
So state is here, no?
I'm not aware of the.
Anyway.
He is a mechanical engineer, it pertains to civil engineering.
All right, you say that this extension of the 1964 Act
Yes,
after the
13 Act.
2013 Act, this has lapsed and therefore it
yes.
can be extended.
Yes,
This is your
yes.
argument, I
No,
think.
my lord, my argument is by virtue of state amendment, can you revive an act which is already, my lord, lost its efficacy?
No, that has to be examined.
Yes, well, that's the argument. Now, my lord, when 2013 Act came,
Counter affidavit. And interim order in the meanwhile, if any, shall continue.
Lord, civil in that case, give a date, no, but I will inform that.
Without
He
date,
said
no
every
case
time
is
date
examined.
is
18 May.
developed.
Item 13,
Normally, in these matters, our modus is that we don't stay, we hear. Because it creates
No,
difficulties.
I think
later.
that here it's a case slightly different, my lord. Perhaps if if I argue lordships will be clear, my lord. Yes.
Okay, respond number one, I file affidavit, will file a reply to that.
When affidavit was filed,
On 18th, we have received letter.
Mr.
MJ Gogoi letter.
Mr. MJ Gogoi, learned advocate from the appellant, submits that he would file a rejoinder to the counter affidavit filed by respondent number one. And let that be done by the next day, we notify and the date.
Also, other respondent, they have not filed any.
Let them.
11 May. Item 14,
Your compensation आपको 40 साल के बाद चाहिए. The state has filed. What else? What other respondents would do? What other respondents would do?
DC, they have not filed any. Only revenue department have filed.
Anyway, we'll
Obliged.
May I please, my lords, in item 14?
Yes.
In this matter, my lord, on the last occasion, my lords were kind enough to direct the state to check if there are vacant seats available. This is the matter where, my lord, my appointment was not given because the university had delayed my degree delivery for 2 months, my lord.
Mr. Kalra, let us see the order dated 24/2/2000.
Certainly, my lord.
Very. Yes, yes. Yeah. So we have almost decided in your favor.
Yes,
We only wanted to know if something could be done about.
Yes, that has been.
Because, they have crossed that age. And that was the time you introduced this no relaxation clause only midway. it is permissible so far as this Prakash Pathak is concerned.
I have received a written instruction, my lord. And as per that instruction, prayer was rejected, my lord.
There,
Prayer was rejected, my lord, regarding the if representation submitted by them regarding relaxation of age, my lord.
I'm sorry, my lord, we're not seeking for relaxation of age. What my lords had asked them to check if there are any vacancies, and they admit that there are vacancies available.
no, he's not saying that. Actually, not heard it.
My lord would just have para 1, last 3 lines of para.
Just a minute.
Certainly.
Now, we were not asking Mr. Katniak for your answer like this, that the contention of the representation submitted for relaxing certain conditions which cannot be found attainable and thus the same is liable to be rejected. We were not asking for that. Were we?
That
No.
they are saying that, my lord, their representation was pending.
Whether it was that we have told you earlier also, please don't pass on such letters. But that's because it's a very unhappy way in which it has been drafted. You have asked for good question. I mean, you have asked for correct information. What they are answering is, they are answering it with their closed mind and perhaps closed eyes also. Who is asking for their legal opinion? No, we are not asking for that. So it is rejected. I mean, we sought some information whether anything could be done. How many posts are vacant? Now, will they say the same thing if we direct them to consider?
That-
This is no way of answering, no? These people are, Mr. Katniar, you faced that earlier
Yes, my
in
lord.
a different matter.
Yes.
Still, you pass on the letter written to you. It's not done. No? You have to reframe it. Now, what do we say with this?
You say that whatever you have asked, it is not the answer. Let them give a present. Don't show it first.
Show it to us.
Just
This is not. See, how many posts are vacant now? Have you advertised the posts? Have you included it in the vacancy position of the next recruitment process? These were the questions that were required to be considered. What are you? What is this director doing?
That, my lord,
What?
query 1, my lord.
Lords, if I may add, there are about 2,000 posts vacant.
Just a minute.
Certainly.
This is a very vague response. This is a very vague response, Mr. Khatnia. You ask them, how many posts remained vacant in that recruitment process? Number one. Number two, has it been carried over to the next recruitment process? If so, we don't have the powers under 142 of the Constitution. We will say that it is over. Three, it's a very vague statement that most of the general category posts have been filled. We don't know. So fresh information is required. That's not this way. And please don't pass on the letter. We get very irritated by this kind of letters.
Sorry, my lord.
We understand that the difficulty is that this has been written inadvertently. I mean, not meaning what it says. They are no experts of writing letters. And it is precisely for this reason that the standing counsel for the department is there. We interact with you. You should reframe it and give it to us, not this.
In future, I will.
Now, in future, you would, but this is the second time that you are showing us a letter which might, propel us to take action or say, or they call the director of secondary education in court, which we don't want to. It's not done. Find out how many posts are vacant. We're not asking you to appoint them. Whether you have clubbed it with the
Subsequent-
next
subsequent
recruitment process, have you clubbed that vacancy? In that case, we'll say sorry to Mr. Kalra. But find out what can be done.
Yes, ma'am.
We are adjourning it for 2 weeks again.
Plus, can I just have 30 seconds? I just want to add something, my lord. I am so grateful for the observation. Can I just take 30 seconds if my lord would
No,
permit?
no, on the next day, let him come with the necessary information.
Very well, my lord.
Otherwise, on facts, the order is as
I
specific.
understand, my lord. I understand.
It could have been dismissed on that day only.
No, I'm so grateful for that, my lord. I'm definitely grateful for that. The only thing, if my lord, just 10 seconds, would my lord permit? Just 10 seconds.
Next day, please find out.
Very well, my lord.
As prayed for by Mr. Kapniar Laman, Scanning Council for the Department of Second Education. Let this matter come up. Next.
Obliged.
23rd April. Item 15.
Can it just be a short date if possible? 23rd April would be another 4 weeks from today. Can I be?
They'll have to calculate, they'll have to see, and then they'll have to
Very
take a
well,
call.
very well, very well.
Ask them to take a call. Ask them to give us, Mr. Katniar, I'm addressing you. Ask them to give the factual position. Don't ask them to decide. That part is left to us.
Yes, ma'am.
It's in our domain. Let them say that these are the number of posts which could not be filled up. We are in contemplation of starting a new recruitment process. We can't help it. But in any case, just give us the information,
Yes, ma'am.
statistics. Please don't ask them to decide the case for us. Correct?
Definitely, ma'am. Obliged.
Deeply grateful, my lords. Deeply grateful.
Item 15.
Regarding regulation, madam, there is one more writ appeal, madam, 156 of 2025. There, madam, the learned single judge has, madam, turned down the, madam, prayer for regulation, which is under appeal. Let it come together, madam, finance is there, madam.
Let this
Next week or any day convenient, madam.
let this writ appeal be listed along with, give us the number. You have the number.
WA 156 of 2025.
156 of 2025.
Ma'am.
ये तो मुझे खोलना है कैसे अपील लिखा है? Along with WA number so and so on up to it.
Yes. Item 16.
Nobody appears on there. Where's any? Today they must have left. Let this matter come up for consideration. Over there.
April. 24th April. Item 21.
Today, we did not anticipate that counter affidavit in one matter would not have been filed, for which all this matter. Let this case be taken up. Let this case be listed. We will not write, Mr. R.K.T. Chaudhary, we are not writing that nobody appears. We had asked them to go. Let this matter be listed for consideration on your date.
28th April.
Dates. But you are here, no? You want to argue?
I am for the appealing matter.
So you're for the appellant.
No, yeah.
So I think,
For the
no, you're for the
for B Devka. I'm appearing on
item
behalf
number?
of B Devka. 21. Item 21.
In fact, from the government side, Rashid, it was.
No, Union of India is the appellant.
Yeah.
इधर आइए ना, you are appealing.
No, no, no.
I'm on behalf of B Devka.
Come this side. In fact, Rashid, our predator was there, but he had left.
Okay. All right.
I'm sorry. Union.
Item 22. 28.
Now, anybody where the parties, where the advocates for the parties are here, we will take it up. Any case where the advocates of both the sides are here, we will take it up. Yes, Mr. Mr. Dasgupta, you are in which matter?
Item number 22, Lord.
Is this the item which has been called, Mr. Roy? Yes. It's उसको रिफंड करिए तब इनिशिएट करिए. Yes, Mr. Dasgupta. It should not be insisted for a refund. We are very clear. Because if it is over certification on account of your complicity, your fraudulent collusion, you went in cahoots with the authorities went in cahoots with you. Then whatever has been recovered. Now no more recovery till the time they decide in the inquiry proceeding whether you were responsible for this overpayment. And then when you come out of the categories of Rafiq Masi, then perhaps they can recover. That's all.
They have already deducted my, deducted.
Not all, not the entire amount.
Yes, the entire amount.
Then it becomes meaningless, no?
That is right.
Mr. Roy, then it becomes meaningless. I was under the impression reading from the order that some part of it has been deducted.
No. Entire amount.
When they approved, the recovery process was started. Recovery in respect of all 122.
That we have followed. That we have followed.
Yes.
But you refund. See, you have to follow the process of law. Refund, initiate proceeding.
Yes.
And or keep it in an escrow account or some account.
My lord, in the other 9 petitions, directions were given to make an inquiry. There was no direction for refund. So, my lord,
They followed that. You, Mr.
most of them will retire, my lord. They will go out of our some, it will be difficult.
Yes. Have you started the inquiry?
No, but lord, others require inquiry
I
completed.
am talking about these.
No, because of the order passed. This is,
There is no order.
yes, my lord. The first make refund, then make inquiry. So therefore, my lord, we are praying for some time to complete the process, and then, my lord, the lordship will grant us some time only. When they can wait for.
The difficulty is this. We don't know. You are out of service. You are not in service now.
No, some of them are service.
No, give us the specific dates. You are out of service. You may like to go somewhere else in Kerala or say Nepal. How come it will be recovered from you? Wait for the inquiry proceeding. We will make it conditional.
Your lordship may kindly fix a date. I shall argue this matter. Probably your lordship will.
You argue now. We are clear in our minds.
What happened in this case, my
We
lord?
have followed what has happened. You argue this. Now, how
CAG.
we have followed that.
Oh,
We
sorry.
know that background. How many of you respondents are still in service?
I have to give the information tomorrow or the after.
So if you are in service, we will say that please refund. If you are not in service, that would not be the condition precedent.
That can be done.
Find out.
Yes, if I have the 3 person concerned who are in service,
Take
the refund.
Take instructions, give us the,
Or I can take instruction also, as your lordship will speak.
when do you want it?
3 or 4 days.
Let me indicate.
Or your lordship can pass an order, the person concerned who are in service.
No, that we don't. If all of them are gone, we will not make conditional orders. What kind of orders?
All, that's all, no problem.
We have heard Mr.
Because the age is also written here. Their age.
We have heard Mr. P.K. Roy, London Senior Advocate for the Appellant Food Corporation of India and others, and Mr. A. Das Gupta, Senior. And Mr. A. Das Gupta, London Senior Advocate for all the respondents. The welcome. At some point of time in the past, an audit by the Comptroller and Auditor General was made of the expenses made by the FCI towards payments made to the laborers between October 2013 and March 2014. And in that audit, it was found that there were discrepancies in the work certification. The stock accounts displayed that there were only 5,700 bags of food grains which were lifted. But payments were made to the laborers for lifting of 2,43,312 bags. The audit therefore revealed an over certification of 1,85,791 bags. The natural corollary of this disclosure was that undue payments were made to the laborers beyond their entitlements. On the basis of the aforementioned audit report by the CAG, recovery from such laborers were initiated from their respective salaries / wages. This initiation of recovery process was questioned by many of the laborers, relying on the decision of the Supreme Court in the state of Punjab and others versus Rafiq Masih, 2015, 4 SCC 334. Which resulted in a coordinate bench passing an order of stopping the recovery presently and resume it only after an opportunity was given to the laborers to explain their cause and further quantification of the amount which was sought to be recovered. While directing for such contingent proceedings, this court had permitted the appellant FCI to conduct disciplinary inquiries. But however, by that time, with respect to those laborers who had challenged such decision of the FCI, recoveries had already been made. Stop. The commencement of the disciplinary inquiries was thus not made contingent on the refund of those amounts, refund of the recovered amounts to the respective laborers. It further appears from the records that after the inquiry, it was found that it was not only a mistake on the part of the FCI authorities, but it was a fraudulent over-certification in which the laborers also had played a role. The decision to recover the excess amount paid to the laborers, therefore, was passed, which, we are not aware whether was questioned by the laborers in a separate proceeding. In the case of the 12, how many of you? 12. In the case of the 12 respondents in this appeal, the recoveries had already been made, but there was no show cause notice to them prior to such recovery. The learned single judge in their cases, bracket WPC number 1223 of 2023, permitted the FCI to conduct an inquiry, but only after refunding the recovered amounts first. This condition was not there in the earlier proceedings with respect to other laborers. That part of the order passed by the learned single judge has been appealed in the present appeal, with the assertion by Mr. Roy, learned senior advocate for the appellant FCI, that such condition was very onerous. And if the amount would be refunded, the amount recovered would be refunded. And it so happens that the respondents are not in the service of FCI, it would be very difficult to re-recover it after they are found guilty in the proceedings, after they are found to be in cahoots with the authorities of the FCI in over-certification and payment. We find substance in the aforementioned submission. Mr. Dasgupta, learned senior advocate appearing for the respondents, submits that he shall take instructions whether the respondents are still in the service of FCI or have superannuity.
Only one person, all that I shall take responsibility because age is there. All that shall take responsibility.
If you have retired, then no refund. We will strike off. We'll modify that part of the order.
Yes. 1 and 12 probably. 1 and 11.
Better.
Because
No refund. If you have retired, no refund.
and
कहाँ चले जाएंगे आप? फिर पैसे ही नहीं देंगे. And you have not questioned that. I mean, yeah, you have questioned, but then the court has already directed for an inquiry as others. But this time the single judge applied Rafiq Masih very strictly for the benefit of Mr. Dasgupta. So when do you want? Any date is no date.
after 2 weeks. After 2 weeks.
Item 26. Item 24.
Item 24, Lordship, you remember this is regarding the second service pension. The matter was pending before the Honorable Supreme Court.
What is that?
Matter has been heard and the judgment is reserved on 22 and 26.
We adjourn kar dete hain.
Lordship, let it be after the view, then maybe by then it will come.
We passed any interim order.
There is.
We had state, no?
Yes.
You won't tell him what of that.
In view of similar matters, in view of matters relating to similar issue pending before the Supreme Court. This case is adjourned for give a date in May end.
25th May, 25th.
View is that this relaxation is not possible. This relaxation clause was introduced only for, preventing people from not getting either of the pension.
There should be one pension, right?
No. It's not a question of one pension only. That issue is difficult. I mean, that is not very difficult to argue. Here it is something else. The argument would be on the fact that it was only 10 months short of the period of 10 years of the second pension.
Lordship.
Now, initially, there was a relaxation clause which said that it could be rounded off for the purposes of pension. Now, this clause of relaxation was introduced, keeping in mind that an army man may not have completed that many number of years of service, that is 15 years of service, for getting his pension in the army. Now he joins the disciplined service corps or whatever departmental service. Defense service corps. Now here also, if 10 months less than 10 years,
he will not get.
He will not get any pension.
Yes.
Relaxation was meant for that. Relaxation doesn't mean that for second pension also the requirement condition has to be relaxed. So this is our view. Let us see what Supreme Court says.
Item 26.
Your Lordship, I seek for adjournment. The contending counsel is not present.
As prayed for on behalf of the appellant and agreed to by the counsel for the respondent, re-notify.
18th May,
Hearing.
19th May. Item 28.
But we have filed the affidavit today, Malad. I have extra 2 copies. Malad, the short tender notice, detailed tender notice, work order, and the comparative statement, everything we have placed. And Malad, that Malad, this is relating to construction of a bridge, Malad, Gifu flyover, and Malad, they have lots.
Yes. So you have just handed over the work to the contractor.
No. In the affidavit, Malad, we have filed the affidavit. There, Malad, we have the tender notice, the comparative technical, Malad, the summary of the technical, Malad, bid evaluation. We have annexed. Two bidders were there. And Malad,
all right. What is the stage of work now?
it is, Malad, flyover is open. On 11/3, it is inaugurated.
Let me conclude.
And Malad, only.
Okay, way forward. Flyover, it has been open to the public. Has it been opened to the public?
For public, it is open on 11th of March, 11/3. My friend is there, Malad.
I don't think there is anything left here.
Lordship, can
I'm not just go through the academic matter.
अभी पढ़ लीजिए, इसको खत्म करेंगे। अभी पढ़िए।
I have extra copies, below. No, but I could file it today. I have 2 extra copies, below.
आपने इनको have you served her?
Yes, sir.
Yeah, don't go by the thickness of it. Read the relevant paragraph.
Or the annexure, sir.
Please tell us the paragraph.
Logic. Para 3, below.
Para 3.
Logic.
Pardon yourself for her to earlier years work.
The opponent states that the name of the work in question is construction of 4-lane flyover from Difu Stadium to Difu Head Post Office to Lumbing Dimapur Road, Difu, Karbi Anglong district in the state of Assam under SOPD-G for the year 23-24. The Honorable Chief Minister of Assam had laid foundation stone and performed Bhumi Pujan on 16/4/2022 for construction of flyover. After Bhumi Pujan, PWD Difu Roads Division has initiated its preliminary work after due consultation with the Honorable CM
Those
KAAC.
details are not referred. So the tender was issued. There were 2 bidders.
Yes, yes.
The contractor was
Kindly
selected.
come to 110, page number 110, 11
बुलाइए तो बहुत मुश्किल।
110. Annexure 1, Annexure A. This is the short tender. Thereafter, the detailed tender has been issued.
Yeah.
114, मतलब the
हाँ सब हो गया है मैडम। Everything is over.
मतलब
I don't know whether this was floated before the work started, but nonetheless, the papers are complete. We would have looked into it if the construction were not complete. Now it is complete. It's open to the public will not.
once
And the Planet Council for a petitioner has also taken a stand on last occasion that he is not interested. Only completion of the stand.
logic. Only मतलब one submission kindly below.
पहले पढ़ने दीजिए।
Logic.
We are satisfied from our part. We can't force an order down the throat of a council who says that you have served in the counter affidavit only today. Where has Mr. Bothakur gone?
He's in code number 15.
Ask him to come.
Logic.
You are finding it difficult to concede.
Logic. Oh, tomorrow.
Why tomorrow today? It's still 15.
Also, I will be allowed to
Huh?
inform you. I will be allowed to inform you.
What is it? Inform him, we'll come back after 5 minutes. This is the last case, we'll come back after 5 minutes. Let it.
Or you have an instruction whether we.
Tell your senior that now we don't want to put it on you. Maybe your senior would say, why did you concede? I would have argued. So otherwise we would not have permitted, but today we only ask the lawyers to go. So therefore ask him that now there is some document which says that the floater, the tender was floated. There were 2 bidders, he was selected, the contractor. And on top of it, everything has been done, it has been open to public. And he had conceded on the first day that he is not interested in removing the carpet, which would let the worms come out. He is interested in the bridge being constructed on time. Because the information to Mr. Bothakur that time was that only 70% of the work is over. Okay. Have you followed what the court has said? Have you followed what the court has said? Communicate this to Mr. Bothakur. If he comes, it's all right. If he comes, all right, otherwise take instructions. We are closing this petition.
One submission, small submission I have. Flyover is open for public, it is there. Some miscellaneous, some works are there. Those will be completed by 31st of March. The miscellaneous work related to the others. Otherwise, flyover is good. Flyover is open. In the affidavit, I have said it that on 31st.
Mr. Bothakur, Lordship, your junior must have informed you.
Lords. This has been constructed, Your Lordship.
So we close it.
Lordship. Only thing, Your Lordship, I just want to point out, Your Lordship, that the manner in which this award of the contract was done, Your Lordship. Your Lordship will kindly come to just for a moment.
Conceded on that.
Lords.
Statement.
Just I have indicated the roadside drain, service road and parking area. That is the whole process. That is not done other than flyover proper is open. That everything will be completed by 31st of 30th of April 2026. Lakshmi record.
We have heard Mr. S. Bothakur for the petitioner and Mr. Dina for the state. An objection was raised that the construction of the 1.4 kilometer long 4-lane flyover on NH 329 at Dipu was begun without resorting to proper tender process. That apart, it was further pointed out that despite the work having been started long time back, only 70% of the construction was made at the time of filing of the petition. However, Mr. Dina, who the affidavit filed on behalf of PWP, submitted that the allegation of the work having begun without following the tender procedure was incorrect. So, after a decision was taken to construct the 4-lane flyover at Dipu, a tender was floated, attracting 2 of the bidders, out of whom the contractor who was made the concessionaire backed the contract. As on date, according to the information provided to Mr. Nath, the flyover has been completed and has been open to public as well. However, some part of the approach road, the drain and parking area are still to be finished. However, with those works unfinished also, the flyover is being used by the public at large. The unfinished work is to be completed latest by 30th of April. In that view of the matter, we do not wish to go further into the purity of the tender process and the selection of the contractor for the aforementioned work. We therefore close this petition with the expectation that by 30th of April, all works shall be complete so that the citizenry is not inconvenienced for anything.
Highly.
Thank you, Mr.
Lots of great.